Now, the next tool that we're going to talk about are depositions. Depositions are a great way of gathering information. They're, in my opinion, necessary before litigation when possible. The reason people don't do it is it can also be time consuming and therefore costly in terms of your fees. But a deposition is where you can get the other side or any other witness, quite frankly, and sit them down and ask them questions under oath for up to 3 hours. In my office, I like to do depositions for 3 reasons. And in no particular order, they are to assess the credibility. Does this person come across as believable or not? Because we as attorneys have to give you what we see. And if your spouse comes across very believable or very credible, that's going to be a problem for us. If they come across as very combative and not honest, that can be a good thing for us. So credibility is one thing. The second thing would be to find other discovery based upon those answers. So sometimes their answers may lead us to something else that we then want to go check upon. And finally, the last reason we want to do depositions is I want to lock them in on their testimony. In other words, I don't care what they say. I don't care what their answers are. But when I ask them the question in a deposition, and then I ask them again in front of a judge, I want the answers to be the same. This way, it can eliminate surprises when we're in front of the judge, because ultimately, the judge is going to hear only the testimony in court. They're not necessarily going to hear the testimony that took place during a deposition. So I want it to be authentic, and I don't want any surprises to come out during the trial.